Okay. Welcome to the Employment and Income Maintenance Subcommittee of the California Paraprofessional Program Working Group. I will call the roll. Fleischman.
Here.
Shining. Make sure that Carolyn's not in the attendees. I don't see Carolyn. Spyro.
Here.
And Judge you said is late. So we have half of our members. I think that constitutes a quorum. Is that accurate, Brady?
Damn.
Okay.
I would assume we can go ahead, and I see that we have.
Sorry, so it's Brady. Sorry, it took me a second there. We need majority for there to be quorum, but
We have two
you know,
of four.
there's right. So no quorum, but you know, that's for a vote. So there's no prohibition on starting the presentations.
Okay, and in fact, what we'll start with is public comment because it actually looks like there are a number of attendees here.
So if there's any members of the public who want to make comment, raise your hand and I'll go ahead and start. And since we have a very busy agenda, Leah, do you want to set a limit for comment since in Judge Yu's absence?
Yeah, let's set it at 3 minutes.
Okay. So our first person is Kelly Ivy. You may begin speaking.
Hi, Kelly McVeigh here with Bedside
sorry.
Legal Services, and we're just here to listen and observe today.
Okay. Thank you, and I'm sorry for getting your name wrong. The next person is Eric Kingsley. You can go ahead.
Hi there.
Apologize, go ahead.
I have my own, Eric Kingsley. I'm affiliated with the California Employment Lawyers Association, as well as I have my own practice. We focus on wage and hour litigation. I just wanted to point out that there are some public policy concerns I would have with allowing paraprofessionals to practice in court. One of the issues that I think is concerning is the fact that you have situations when an award is issued in a Berman hearing by the labor board. If a claimant were to appeal and they lost, they could be subject to attorney's fees by the employer. And in all my years of practice, I have always counseled employees against appealing in that circumstance, especially if someone has assets of any sort. They could lose their house, have a major judgment against them. And so that's one concern I have, is that the right advice would be given to those employees. If one paraprofessional were to appeal in that circumstance and was wrong, you could have really serious implications for that potential client. And the other issue is in a situation where there's an award that the employer appeals, I think there'd be a large number of attorneys that would take those cases, in part because in the Berman hearing, if the employer loses, they have to bond the amount of the award. And so that would create an incentive because there's a pot of money there and collection becomes less of a concern. And then the other reason is because you can get attorney's fees on a one-way basis if the employee is the non-appealing party. And so there'd be a number of lawyers that would take those cases. And then one last point I would make is that on the issue of attorney's fees, if you read the labor code statute, it says reasonable attorney's fees. So there's an interesting question that the courts would have to answer, is whether or not a paraprofessional would be able to recover their time in a successful appeal of a Berman hearing, and whether or not that could actually hurt the employees by having to pay out of pocket for those fees. Thank you.
Okay, we now have Leonard Sansenowicz.
Leonard, are you?
Mr. Sansenowicz, you have permission to speak. You've been promoted. Oh, looks like he's connecting to audio now. There you go. Oh, it looks like you're muted.
Hello, everyone. Sorry to be late.
It's you.
We're waiting for Mr. Sansenowicz.
And this is
Looks
Carolyn.
like he's
also.
having trouble connecting to audio.
Oh, I'm sorry to hear that.
I'm
Have you,
dialing a little late also.
oh, hi, Carolyn. Have you had a chance to take roll yet, Linda?
Yes, we did, and I will add you and Carolyn both to the roll.
Oh,
Mr. Sansenowicz, are you able to speak now? Is your audio? It looks like his audio is still not working. And we have
Miss,
maybe we have another person. Should we go ahead and move on to the next person, and then we can come back?
Sure.
All right. So Jeannie Harrison.
Hi, are you able to hear me?
Yes.
Oh, great. Okay, Jeannie Harrison from Los Angeles, and I am an attorney with CALA Consumer Attorneys of Los Angeles and also a member of CELA. I wanted to just bring a little bit of a bigger picture concern similar to one that I raised before with regard to the Department of Fair Employment and Housing and this subcommittee's work. The state of California has an entire agency dedicated to wage and hour law enforcement. That's the Division of Labor Standards Enforcement and Labor Commissioner. The DLSE has 5 fully active units: the Bureau of Field Enforcement, Wage Claims Adjudication, Retaliation Complaint Investigation Unit, the Public Works Unit, and Licensing and Registration. A number of those actually have to report to the legislature on an annual basis. Confidential investigations, enforcement actions, lawsuits by the DLSE against employers, impact litigation, which is strategic, penalty collection, and appeals happen from these units. In 2019 alone, California collected $88 million in PAGA penalties from litigation and enforcement actions. A potential paraprofessional representation could substantially impact this sister state agency with enormous revenue generation each year. So I do think that this committee should have appropriate representatives from the DLSE testify to guide you on how not to negatively impact important California policy objectives and revenue generation. Paraprofessionals representing employees in the DLSE and just like workers' comp hearings or appeals could very well be a solution that's looking for a problem. Extensive state agency and regulatory systems are already in place. And we don't have the DLSE saying that the system is broken and that they need fix from the state bar or for the state bar to find a solution. In addition, I want to bring up a concern about the fact that there are class actions that could potentially be impacted by paraprofessional representation.
30 seconds left, please.
Thank you. Where even under CCP section 382, adequacy of counsel is a requirement. So there are a lot of overlays with existing state regulatory agencies that enforce these issues and have existing hearing structures. And then there are overlays with potential additional California civil actions that involve representative actions and class actions and potentially federal law as well, which I think you'll hear more about. So thank you very much.
Thank you very much, Ms. Harrison. Appreciate you being here. Let's see if Mr. Sansenowicz has sound now.
Can you hear me now?
Yes.
All right, great. Thanks. I had to call in. Thank you to the committee for allowing me to speak. You know, I recognize that, sorry, I'm a plaintiff side practitioner. I also am on the executive board of the California Employment Lawyers Association, but I also write the wage and hour case summary every other issue for the State Bar Law Journal for the labor and employment section. And so I'm very familiar with these issues. I recognize that the subcommittee has two overarching concerns. One, that that particularly low-wage workers have access to adequate representation and affordable representation. And number two, that the paraprofessional program can create job opportunities for people who traditionally have been, who have not had access to legal jobs. And those are both laudable goals. I think the concern is just if it actually helps in certain circumstances in the wage and hour context. And so, for example, to my colleagues' points where attorneys' fees are implicated, plaintiffs' attorneys in the wage and hour context work on contingency fee. They don't charge low-wage workers any money. And so the idea that a low-wage worker would have to pay an hourly fee is actually antithetical to the current system. But I also want to draw a distinction between individual claims and class and representative claims. Class and representative claims in Los Angeles County and Orange County and several other districts, I think San Bernardino County, are deemed complex for a reason. There are huge volumes of data involved in many of these cases. The judges who sit in the complex courts are very familiar with these with the law and with these concepts. It becomes expensive, perhaps prohibitively so, for a paraprofessional to maintain one of these cases. So while I understand that there is space in the DLSE for DLSE hearing representation, certainly anybody can represent a claimant at the Labor Commissioner, I'm just cautioning against too much involvement in the court, particularly when we're talking about wage and hour. I think the vast majority of wage and hour claims that are brought in court are representative claims, whether they're class action claims, where Ms. Harrison was talking about how
30 seconds left. Thank you.
Thank you. One of the prerequisites for certifying a class is adequacy of counsel, adequacy of representation. And PAGA representative actions, which are actions to collect penalties, civil penalties on behalf of the state. And that, I can tell you from my case summaries, is an area, a field that is very fertile, and new cases come down every month, nearly every week. So one really needs to stay on top of that. Thank you for my time.
Thank you so much. We appreciate your comments. And if that's a picture of your dog as your profile picture, very cute. Thank you.
It's actually a selfie, but thank you. No, it is my dog. Thank you. I appreciate it.
Sure. You would have to say, Your Honor, I'm not a dog instead of I'm not a cat. Yes.
But I'm still ready to go forward, Your Honor. Yes. Thank you.
Thank you. Are there any other members of the public who would like to make comment at this time? I don't see any other hands up. And Linda, if you see them, let me know.
Okay, thank you.
Okay.
I don't see any hands up.
Okay, thank you so much. And again, to everyone, I really apologize that I'm late. I was in a meeting I could not leave. We really appreciate that we have so many speakers here today. And I want to thank staff, particularly Leah. I had communications with her over the weekend, and I know she's been working very hard to vet and locate our subject matter experts who are going to speak to us today. So I'm going to turn it over to Leah, unless our chair, Justice Petru, would like to say anything.
No, I think we're good to go.
Okay, thank you.
Great. Linda, do you have the PowerPoint loaded or just this slide?
I have the PowerPoint loaded.
Okay, let's advance the slide. So we are, as Judge, you mentioned, and I alluded to earlier, we're really lucky to be joined by a host of subject matter experts today. I am not going to read their bios from their website, but ask them to briefly introduce themselves when they present. But I did want to sort of give an overview of the composition of this group of experts. So we have Ms. Danielle Jones with Stanford Community Law Clinic and Ms. Ruth Silvertop with Santa Clara University School of Law. Both here today in simple terms, from my point of view, to talk from a worker's perspective, bringing cases on behalf of workers. You have Ms. Jennifer Lutz, who represents employers in wage and hour proceedings. And then we're going to hear from Chip Aubrey, who is now with Morrison & Foerster, but was previously our state's labor commissioner. And then sort of closing things out, thinking of this somewhat sequentially, we're going to hear from Judge Manukian with the Santa Clara Superior Court about what happens with wage and hour matters when they move over to Superior Court. So we're really lucky to be joined by this group today. What I want to do before we turn to these experts is to review the paraprofessional licensing requirements very briefly. And I've been thinking about the need to do this in all of our various subcommittees, because as I've been talking to experts to prepare them to present, one of the questions that invariably comes up is, who are these paraprofessionals going to be? And it's hard to sort of imagine what might be possible without just a basic understanding of what the working group is contemplating in terms of the licensing requirements. So I'm going to start there very briefly, and then we will turn to Danielle Jones and Ruth Silvertop to kick us off. So Linda, could you advance the slide? So in terms of the licensing requirements, I'm not going to go into this in great detail, but the one important takeaway is not just anybody sort of walking in off the street will be eligible to become a paraprofessional. Right now, the working group is contemplating that only JDs or LLMs, so those who have gone to law school or completed an LLM program, or paralegals qualified under the Business and Professions Code will be eligible to become paraprofessionals. So that's a really important sort of threshold licensing requirement. In addition, there will be universal educational requirements for paraprofessionals, which you can see on the screen. These universal requirements will be augmented by practice area requirements. So for each practice area that is authorized, there will be practice area specific educational requirements. You can see here that family law has been built out to some extent, an additional 9 hours of coursework on top of the universal requirements. All other practice areas have yet to be developed, but it's just an important part of the framework to understand that there will be universal educational requirements and then practice area specific requirements. If you could advance the slide, Linda. In addition, there will be a requirement for experiential training, 1,000 hours of experiential training, 500 of which needs to be in the intended license practice area. And to clarify, the paraprofessional license will be practice area specific, unlike a legal license, which is, as we all know, is a generalist license. So you can see here that there will be both educational and experiential requirements, and at least half of the experiential requirements need to be in the practice area for which a license is sought. You can move on, Linda. The last components are subject matter specific testing that aligns with the subject matter specific licensing. And of course, the moral character and background check process. And that process is at this point contemplated to align very closely with the moral character process for attorneys. So I wanted to lay that out really for all of our panelists to see at the same time, because these questions keep coming up, and I do think it's important sort of context setting for this conversation about what paraprofessionals might or might not be allowed to do. And with that, I'd like to turn it over to Danielle Jones to kick us off, and followed by Ruth. Oh, Judge, let me ask this. In the past, we've sometimes had questions for each panelist after they speak. Other times, we've waited until all have spoken. I don't know how you prefer to proceed today.
Do the panelists have time constraints where they would have to leave after they speak, or would they like to hear what everyone says and then we can have all the questions go to all the panelists at the end of their presentations? Does any of the panelists, just Judge Manoukian?
I have a bit of a time crunch today, but I'll stay as long as I can. This is a very interesting topic, and I'd like to stay as long as I can.
What time do you have to leave, Judge Manoukian?
4. I have another commitment at 4 o'clock.
Okay, well, I commit to have us be done by 4 because we're supposed to be done by 4.
Perfect.
Okay, thank you, Judge Manoukian. Anybody else have any time constraints? Then unless there's a burning question, I think it would be probably useful if we wait till the end. That way we can just have presentations and then more of a free flow with questions going to whoever needs to have the question. Is that okay, Leah?
Yes.
Okay, great.
All right. Danielle.
Well, good afternoon, everyone. Thank you, Ms. Wilson, for the introduction and invitation to speak to the subcommittee today. It is indeed my pleasure to do so. I want to give just a little bit of my background so people understand sort of where I'm coming from and my perspective, which is very much rooted in my public interest career practicing as a California attorney for the last 20 years. I launched my career doing fair housing cases in Los Angeles, pressing federal and state fair housing cases on behalf of my clients. And I've spent the last 17 years working at the Stanford Community Law Clinic in a clinical education program cited in East Palo Alto until recently when gentrification displaced us. But for years, our law office was in East Palo Alto, where our primary focus has been representing workers on wage and hour cases, eviction defense, and my primary focus now in my life and has been for many years is post-conviction relief matters, helping people clear their criminal records so they can successfully reintegrate into the community. What I can say is of my 17 years mentoring and teaching Stanford law students alongside my practice, I mentor them in a clinical law program. Sounds like folks are familiar with that structure and setup. I have to say that nearly all of the DLSE cases that I've worked have been in the DLSE realm. The workers' rights cases I have worked have been in the DLSE realm, with the de novo appeal sprinkled in here and there, but for the most part, focused on pressing these claims in the administrative realm in front of the Department of Labor Standards Enforcement Administrative Agency. I've represented alongside my students and in my individual capacity as an attorney, clients ranging from restaurant workers to housekeepers to convenience store clerks and everything in between. I would say I've spent, of my 17 years at Stanford, maybe 10 years intermittently working these cases in the administrative realm. And what I can say with great confidence is that we always had more clients than we could ever possibly serve, particularly when it comes to industries like the restaurant worker industry, where there are a lot of practices that you see that repeat and are fairly commonplace in terms of wage theft, in terms of rest and meal break violations, and on down the line. But I want to make that point very early on. Always had more clients than we were ever able to serve. So I want to spend a couple of moments just talking about what my experience in the administrative realm was like, and sort of maybe talk a little bit about the details of that realm that might come into play for a paraprofessional slipping into this role or coming into this role, adopting some of this work or helping litigants with this work. What I will say is that the DLSE process is intended to be informal and accessible. It is intended to be both accessible and informal. But what I'll say is that whether or not I worked on a complex case or a more simple, straightforward case, there are certain aspects of these cases that are consistent. It doesn't matter if it's a 3-year statute case or something where someone wasn't paid for 2 weeks. There are complex sort of behind the screen things that litigants and petitioners and claimants really do need assessment and help with. One is assessing what wages are due. So literally getting a handle on someone's timeline, how far back their claims go, and helping clients crunch those numbers. It can get kind of complicated. Looking through documentary evidence, for example, pay stubs, time cards, schedules, all of these things have to be analyzed to get a full picture of what your client's particular claim might be. So there's a lot of number crunching and a lot of, how do you say, getting a sense of how long the employment lasted, getting a sense of the client's hours, and then on top of that, doing the calculations for the straight wages that are owed. On top of that, you have to be concerned with all of the penalties that can attach. Rest and meal break penalties that would attach if someone doesn't get their proper meal period, there's a penalty for that. If they don't get their proper rest breaks, there's a penalty for that. And then on top of that, there are waiting time penalties that our clients are entitled to should they not be paid in a timely manner. Last I checked, it's been a couple years since I've worked these cases. As I mentioned, I primarily focus on post-conviction relief cases at this point. But last I checked, if the employer goes beyond 30 days, having outstanding wages owed to their workers, they're going to be subject to a waiting time penalty, which also needs to be calculated. So all of this to say, there are a lot of calculations involved in these cases and a lot of document review to the extent that our clients have pay stubs and time cards to review. Sometimes they don't. In terms of the actual process at DLSE, I mentioned that it is designed to be informal and accessible so that a pro se litigant can navigate the process on their own or have legal representation or less formal representation in the process. But again, I mean, my experience is that a lot of clients in this realm might have English as a second language. I've represented many Spanish-speaking clients. And so navigating even an ostensibly straightforward process can be challenging for people who are working full-time, who are trying to get their wages, and they don't really have the time to hustle down enforcement of judgments after they go through the DLSE process, hopefully to a successful result. Even at that point, if the hearing examiner hears testimony, takes evidence, allows cross and direct of the parties, at the end of that process, if there is a favorable decision entered on our client's behalf, the client still has to go about the business of enforcing that judgment, which, as many of us know on this call, is a very onerous, burdensome, long-term process. And so that is something when I think about workers, and I'm going to be fully transparent, I've represented tenants and workers, so my perspective is very much in terms of lifting and elevating that particular cohort and group of people and empowering that group of people. So from my perspective, when I think about DLSE processes, sure, the point of entry might be somewhat, the bar might be somewhat low in terms of the informality, but in terms of breaking these cases up, it does take some focus, it does take some time, and it does take some breaking up, as we say. So let's fast forward. Our client is successful in her claim, and the hearing examiner finds for our client, and there is a decision issued that is favorable for the petitioner. At that point, the employer can, of course, do the right thing, which is pay up. That doesn't always happen. So the next step, of course, is to try to go through the formal mechanisms of getting that DLSE decision converted to an enforceable judgment, which last I checked involved going to the Superior Court, filing the appropriate documentation, and converting that administrative agency's findings to a formal enforceable judgment. It's at that point that I think it gets rather challenging for litigants and for claimants, because you really have to be able to chase the material down. I know that in the cases that I've done historically, I have done a few debtors exams, or also formally known, I guess in its formal titling would be an order of examination, which is where you basically demand that the employer come to court. Back when I did it, it was handled in small claims court. And you can ask the employer a variety of questions about their assets, from bank account information, real property, et cetera. I don't know if the rules around that have changed, but certainly when we were trying to convert DLSE decisions to enforceable judgments, that was part of the process, because you want to get that information so that then you can take advantage of all the mechanisms of enforcement that are available to your client at that point, whether it's levying a bank account, whether it is putting a lien on real property through the county recorder's office, whether it's doing a till tap at a restaurant where you're actually going to the cash register and pulling out cash to the extent that it satisfies whatever part of the judgment you can get. And then the remainder, you're stuck trying to chase down through other mechanisms. So for me as a practitioner, I can say that I have gone through that process. I don't see any of my clients going through that without assistance. I don't see them finding the time to do it. I don't see them, having the resource output and ability to chase that judgment down, go through the conversion process, etc. So I think I'll leave it there. The only thing I do want to point out is that I think to this idea that, private bar is available to take these cases and would take these cases on a contingency, I guess my question to that assertion is the question of whether or not, maybe on the strongest cases where it looks like there's going to be the party's going to prevail, but not every case is that clear. A lot of cases are in that midline space. There's no smoking gun, there's no documents, there's word against word. And so at that point, you're left bricking up testimony and really trying to put forward your client's story. And so I guess I would question the notion that private bar would take all of these cases when I think about my own practice and the fact that many of our clients were low income, no question. But I query whether or not all of those cases would be picked up on a contingency. I think there's some complexity and nuance to that in reality. So with that, I'll stop. I could probably go on for a little bit longer, but I will pause there and give it to our program director to direct traffic.
Thank you, Danielle. Ruth.
So I put together a very little PowerPoint, and I don't want to repeat anything that anyone else has said, but I was a plaintiff's attorney. I now supervise the Alexander Community Law Center's Workers' Rights Clinic. I also supervise attorneys funded by Santa Clara County at the Step Forward Foundation, a nonprofit that represents, shouldn't be who, clients at the Labor Commission, the DFEH, EOC, CUIB. And I supervise the attorneys on the Santa Clara County Office of Labor Standards Enforcement's advice line funded by the Office of Labor Standards Enforcement. And these are my former students, and some are volunteer attorneys, and they speak English, Spanish, Vietnamese, Tagalog, Visayan, Mandarin, Hindi, and Punjabi. And all these services are free. I'm also a member of CLIWA, and that is the Coalition of Immigrant and Workers Advocates. The members work at nonprofits, and they represent clients at the Labor Commission. They're mainly lawyers, but those who are not have an attorney on staff. For example, MCTF, where Lilia, who's the Labor Commissioner, comes from, or California Domestic Workers. They work with the Women's Employment Law Clinic at Golden Gate. Or they work closely with an attorney at a nonprofit like Beth Sedek works with warehouse workers. They're also culturally and linguistically diverse, which is really important. And just to give you an idea of, for example, CLIWA member Legal Aid at Work has clinics, and I'm special counsel to them, but they have clinics in Watsonville, Santa Ana, San Diego, Merced, Visalia, Santa Ana, San Bernardino, and Sacramento. CRLA has offices in, you can read this, but Arvin, Coachella, Delano, a lot of different places, Vista, where you wouldn't expect them. So CLIWA provides extensive training resources and a network of lawyers that regularly email, discuss strategies and case law, and refer clients to nonprofits in the area. Members of the CLIWA Administrative Committee also meet regularly with Carlos Torres, who runs the wage adjudication unit at the Office of Labor, the Labor Commission. And just last week, we met with Patty Huber of the retaliation unit. We also have a liaison who meets with the EDD and can escalate, there's been lots of problems there. We communicate regularly with these agencies about our concerns, and we provided input on the claim forms, which weren't particularly user-friendly. And they also refer cases to our law center. Just this morning, we received a referral. And I just want to give you an idea. I am not going to read through all of this, but of the members who provide legal services. So this is A to C, C to C, E to K, L to M, N to T, U to Y. The cases we handle are typically low dollar cases. I'm not going to repeat what the other speakers have said, but we represent them at no cost. If clients have to incur costs by hiring a paraprofessional, they'll lose a part of the wages they're owed. We don't do litigation, but you've heard some speakers from California Employment Lawyers Association, and we know and trust these lawyers, and we refer to them, and many of us are also CELA members. CELA is really, I hope they don't mind, but I think they're kind of like CLEWA in that their members are plaintiffs' attorneys. They conduct these wonderful educational programs, and attorneys regularly communicate with each other about issues that arise in case law. So non-lawyers can already represent clients at the Labor Commission and other administrative agencies. I'm concerned that these paraprofessionals will be trained in a very narrow area of advocacy and will likely have trouble adequately issue spotting because there's often overlapping legal issues, and often they're complex: retaliation, discrimination, leave acts, and workers rarely have one issue. I teach law students and I see the difficulties they encounter in identifying overlapping issues in complex cases, and even not cases that are complex but have other issues. Also, cultural and linguistic competency is really essential. Working with this diverse group of lawyers that I work with, I realize it's reinforced for me how important that is. Many vulnerable clients are illiterate or monolingual, and even well-meaning advocates, and I've seen these over and over again, who lack supervision and cultural competency will give wrong advice. And I know even during my clinic, I must say every clinic, now that we're doing it virtually, I get calls from the attorneys just wanting to make sure that the advice they gave is right, which they're attorneys and I train them, so usually it is. And also I did look over Washington, Utah, Colorado, and Oregon, and these states contemplating using what they call LLTs. I don't know exactly what that stands for, are not using them or contemplating using them for employment law. So we do have a gap. In that after the Berman hearing, as you know, if the employer doesn't appeal or pay the judgment, the Labor Commission records the judgment in Superior Court. According to the UCLA Labor Center, only 17% of those judgments are corrected. Currently, Wage Justice in Southern California is the only nonprofit that collects wages. And at one time, the Labor Commission contracted with them. However, even in those cases, they can be very complex because there may be issues of fraudulent transfer, bankruptcy, fraud. And since the passage of SB 588, the Labor Commission has tools for collection, such as liens and levies, that are not available to a plaintiff's lawyer or to legal services attorneys. You heard about the TILTAP and all of the other order of examination. They have much more. They can just write to the bank and get the money. And a Labor Commission pamphlet describes the collection process and then states, you may consult a nonprofit legal service provider in your area. You may also hire a lawyer or collection agency to help you collect. Find a reputable attorney who has experience with debtor-creditor law or commercial debt collection, sometimes called creditor's rights attorney. So I would say that we need to fund this enforcement units. There's thousands of uncollected judgments. The Labor Commission, JEU is very small. These attorneys are outstanding. Julie, Sue, and Lilia was able to bring a lot of them over from Wage Justice, but there's too few to handle the volume of cases. They need more funding and they need to hire more attorneys. And we want to encourage attorneys. I mean, we all do, to do nonprofit work. Legal services attorneys are paid very little. Paraprofessionals will foreclose opportunities to do this work and divert resources from legal aid services who could pay attorneys more. I believe that legal services could be paid more and it would attract more people, even though, as I showed you, there are quite a few of those. The state bar is admirably attempting to expand access to legal services through innovation, but it shouldn't take the opportunity to incentivize advocates to pursue careers in public services by creating financially viable pathways to practice public interest law. It should create viable pathways so that they can earn enough to practice the law.
Thank you. Are you done, Ruth?
I am, yes.
All right, Jennifer.
Hi, everybody. I'm Jennifer Lutz. I am a founding attorney and chair of the employment team at Pettit, Cone, Ingrassia, Lutz, and Dolan. I'm in San Diego. Our main office is in San Diego. We also have a Los Angeles office and offices in Arizona. Sadly, to my mom's dismay, I am not in the Arizona office where I'm a native, but can't leave the beach in San Diego. It's an absolute pleasure to be here with all of you this afternoon and to talk from my perspective as an attorney who solely and exclusively represents employers. So let me give you a little bit of my background and what that means and what I do on a day-to-day basis. As I indicated, I am in San Diego. We only have one Qualcomm here in San Diego. So my client roster is lots and lots of small and medium-sized employers, family-run businesses, mom and pops, if you will, run the gamut. My days are spent in both doing employment counseling, which is being on the bat phone 24/7 for my clients and making sure that they stay compliant with California law, deal with any issues that come up. And then also litigation and the spate of employment litigation from sexual harassment, retaliation, wrongful termination, and of course, lots and lots of wage and hour. So that's what I do. That's how I spend my days. I spend, just for example, today, a client yesterday got a demand letter from an attorney, and it was a 26-day employee. The sole and exclusive wage and hour issue had to do with whether a discretionary bonus in the amount of $100 that the employee was entitled to twice over the 26 days, calculating that, not to get too much into the weeds of the complications of wage and hour law, but whether that was properly calculated into the regular rate of pay for overtime hours. So that was it. That was the demand letter. That was the issue. That's what I spent this morning working through with my client. That is just one example of countless demand letters that I get through the days and through the weeks of relatively smaller dollar issues that my clients are dealing with and working through the liabilities and then potentially resolving them. And then, and you know, for the most part, those are resolved. I don't have statistics, obviously, from defense firms throughout the state, but I know from my own experience in dealing with these demand letters and relatively minimal numbers. And, you know, frankly, and discussions with plaintiffs' attorneys when getting those demand letters and working through the issues with my clients, and the discussions are, you know, Jennifer, if this looks like an issue, even though if it's an X dollar issue, if your client forces us to litigate this, we will get our attorney's fees and there will be a 200, 300,000, you know, whatever it is on the backside of this. And so that's something that is an issue that I work through with my clients day in and day out when dealing with, you know, what seems to be relatively small dollar wage and hour issues. I also spend time with clients going through, I don't want to harp on, there's already been a lot of conversation about the labor commissioner process, and it sounds like we're going to have some commentary with someone much more experienced in that area than I am right after me, but going to the conferences and Berman hearings and dealing with those issues as well. I guess in summation, and I'm happy to answer any questions, which sounds like we're going to leave until the end, on a daily basis, and I've been practicing, I was counting this at the beginning, for 24 years, which is really hard to believe. On a daily basis, I am helping California's employers assess through these wage and hour issues, which seem to be low dollars, but at looking at the complex nature of California's employment laws, the various potential penalties, and then the, potential attorney's fees, not just paying my bills, but paying the bills on the other side too, and, analyzing that all the way out. So for something that may seem relatively small, oftentimes, perhaps even most times, it isn't. But that is my perspective as an exclusively employer side attorney. So thank you for your time today.
Chip.
All right, thank you very much. My name is Lloyd Aubrey. I'm a lawyer with Morrison and Forrester now. Jennifer, when you got 45 years of law practice, then you can talk. So I just passed my 45th anniversary a few months ago. Anyway, Leah asked me to talk because a long time ago I was labor commissioner, and I guess she had trouble getting somebody to come from the labor commissioner's office. But I can say that if I was still labor commissioner, I would accept and welcome all the help I could get from paraprofessionals or anybody to help with wage claim processing, because in fact, the labor commissioner has always been understaffed. It's always mystified me why it is so hard to get additional staffing for the labor commissioner. Even I was labor commissioner from 1985 to 1989, and we put in requests, and even with overwhelmingly Democratic legislatures, it was hard to get additional funding. I was labor commissioner, as I said, from 1985 to 1989, and then I was also director of the Department of Industrial Relations from 91 to 97, which oversees the labor commissioner. I was then for the last 25 years, I've been practicing at Morrison and Forrester, and a lot of my practice has been expert witness work based on my time at the labor commissioner. Testified at a number of trials. Testify probably an expert witness mostly on the defense side, but occasionally for plaintiffs as well. And I've actually testified as an expert at a DLSE hearing about 1.5 years ago, as well as handling some cases at the DLSE myself. The Berman process has been around since the 70s. And it was in the 80s during actually my time in office when we mandated the conference procedure, where after someone files a claim, the claim can be sent to an informal conference, which is handled by a deputy. I mean, one thing that hasn't really come up here so far is the people that work at the labor commissioner's office, at least in the wage claim adjudication process, aren't really lawyers for the most part. There's a progression of positions. It's called deputy labor commissioners. There's a deputy labor commissioner 1, which is considered the line deputy position. The deputy labor commissioner 2, which is the hearing officer position, and the deputy labor commissioner 3, which is the senior deputy that runs the local wage adjudication offices and the BOFI offices as well. But anyway, so people tend to come up through the system and they learn about wage and hour law first as a line deputy, and then they go through the promotion process to become hearing officers if that's what they want to do, or try to become a senior deputy. So they're not lawyers, but they're just trained in wage and hour law. And a deputy labor commissioner one, though sometimes other ones, handles the wage claim conferences. And at these wage claim conferences, the idea was that a lot of times the employers don't necessarily know what the law is. The claimants don't really know. And it was a way for the parties to get together and sit down and try to figure out if there was a way to resolve this case, or if in fact there was some other issue involved that might require dismissing the claim and not going forward at all. And then if it is not resolved at the conference, then it goes to a hearing. And again, these hearings are intended to be very informal, I think, as Ms. Jones was talking about. They're taped. They're not, there's no court reporter. They're just taped. And most of the times the recordings aren't transcribed. It is intended that the person could represent themselves. But oftentimes the hearing officer takes control of the hearing to begin with, and the hearing officer sort of directs the initial collection of testimony and evidence. If in fact a couple of the parties are represented, the hearing officer might do it differently, but generally the hearing officer controls it because of the fact that for most of the time there aren't attorneys involved. One of the parts that takes place before the actual hearing is the employee has the right, and the employer, to subpoena documents. And it seemed to me that might be a place where some kind of paraprofessional could be useful in helping an employee or an employer draft a subpoena and get the appropriate records. And just in general, having someone to help the employee kind of figure out what the issues were, at least from the labor commissioner's perspective, I think would be welcome. And then after the hearing, a decision is issued. It's supposed to be issued right after the hearing, and then the appeal process. But it does seem to me, in listening to the presentations from the other presenters, that there are kind of a number of places where a paraprofessional could be useful. At the beginning of the process, when the employee is trying to figure out what the claim is, if there are additional things that could be sought that the employee might not even know exist, as the potential representation at the conference, representation in terms of drafting a subpoena, representation at the hearing, and perhaps arguing on behalf of the employee at the end of the hearing, and then helping with the appeal process afterwards. So, I mean, it's from the labor commissioner perspective, I can't imagine that the current people running the labor commissioner office wouldn't be very receptive to this idea, because it's going to take pressure off of the deputies who, as everyone knows who does any kind of practice before the labor commissioner, are very hard to reach, are very overwhelmed. And one of the problems with the process is it just takes too long, even though there are these statutory requirements of when things have to be done. The reality is that because of the backlogs that exist, it can take 6 months to a year to get to a hearing or a conference. And that's really not the way it should be. So I'll stop there and we'll go on to the next speaker.
Thank you. Judge Mankian.
Thank you. So I've been a judge for 28 years. My practice before that was personal injury defense and medical malpractice defense, and any employment case I had was pretty much a tort case as opposed to breach of contract case. We didn't get into the depths of employment law. Now that my son is working as full-time as an employment lawyer on the management side, he's the one educating me on employment law, and doing my own education as well. I see employment cases both in the full-blown Superior Court breach of contract tort claim with able counsel on both sides, as well as the appeals of the labor code, labor commissioner hearings. And I can see where everything everybody has said today can fall into place. When I was a new lawyer, I attended a seminar by a lawyer named Jay Foonberg in Los Angeles, saying, as a new lawyer, don't take pro bono cases because then you put the pro bono lawyer out of work. On the other hand, seeing people with cases now that if they had a little bump in the right direction, there could be a better outcome for them. They sometimes are late in filing appeals. They are they appeal the wrong thing. They put the wrong information in the blanks and so forth. Just like in unlawful detainers and even probate cases, a lot of the legwork is done by paralegals, and there ought to be some way that in the employment case, there can be well-qualified paralegals or retired attorneys or inactive attorneys who'd be willing to do something like this and help people with the basics of getting the right evidence into the court and getting subpoenas issued and timely notices filed and so forth. Heck, at a minimum, we put on summonses that are being served that you have 30 days within which to answer the complaint once you're served. We put that in English and Spanish. We don't put it in other languages, and that's giving people important legal advice. And it's not, in my view of things, not out of the realm of possibility to have a qualified, trained professional help the attorney, the pro per litigants get started with at least getting into the court. Most of these Labor Commission appeals are court trials, and the judge is willing to bend a little bit without compromising the impartiality about things. And I'd like to see something done to help a lot of these people, and small businesses especially, that there's a lot of downside for both the employee and the employer if there isn't something that can be done. I've seen small claims cases involving employment cases, small claims appeals, and so forth, and being able to get paid for an honest day's work, or being expecting that your employees are going to be working honestly for the pay they get is pretty important for both the employer and the employee. I really don't have much more to add other than, comment on, I think, all the comments that I've heard so far, especially those of Mr. Aubrey and Miss, where'd you go? Miss Harrison, I think, the lawyer from San Diego. Oh, Miss Lutz, there you are, yeah. My oldest boy went to University of Arizona a while back, so been to Arizona, Tucson area quite a bit. Anyway, I don't have anything further to add. I think that this ought to be looked into, and anyway, thank you for the opportunity to put in my my small contribution.
Judge Manoukian, just one quick prompt. Do you have any experience in the enforcement of judgment question? You spoke about the appeals.
Yes, yeah, we, I have a proper litigant who is tenaciously suing a defunct business and the owners with orders of examination and writs of attachment. And obviously she's spoken to somebody. I suspect she has an attorney on the side that's helping her. She has perfect papers. She knows what to say. Somebody gave her advice. I'm pretty sure that's, I don't think you can look that up in a Nolo Press book, everything she's doing. I have had small claims appeals where, well, in fact, the one I remember the most, a group of Hispanic men were hired by a Hispanic contractor to break up a concrete slab with jackhammers, picks, and sledgehammers. And They did that for 2 days. They filed the employer told them, well, you're all illegal. I'm not going to pay you, so you're on your own. And they did the right thing. They filed a small claims case. The employer didn't show up. They filed a notice of appeal. None of them spoke English. They brought a translator with them and they had obviously talked to somebody, because all their paperwork was all in order, and they got judgment on the small claims appeal, and then they came back with all the paperwork with writs of attachment and so on and so forth. So I usually see these cases for enforcement, however, most of the time somebody's bankrupt or gone or lost. So I don't see as many enforcement actions as I do seeing the original actions that are being filed, the Labor Commission appeals or so forth. And then the cases with that have gone to verdict or settlement, maybe there was a settlement pursuant to CCP section 664.6, payments over time, whatever. I see those fairly regularly, where someone will file a motion to enforce the stipulated judgment or stipulation pursuant to the statute. And again, I know a lot of the collection firms and so forth that do this, the credit card collection companies and so on, the vast bulk of their work is done by paralegals, not by the attorneys. And they seem to do just fine moving cases through the court. I'm sure, an attorney oversees that and all, but a lot of times when the attorneys on those cases do show up, they don't know that much about the particular case. In employment cases, like I say, they're either with well-heeled counsel on both sides, or sometimes there's somebody that's overmatched, an plaintiff lawyer, employee lawyer, or employer lawyer. Most of the time on self-litigated cases, I'd say it's probably even Steven as to how many show up in court without a lawyer, employer or employee. I do have quite a few employees appearing on their own, and employers as well, that, the small mom and pop business is usually the case. It's hard to see things over time because cases do take a while to move through the system from the time of filing to trial to enforcement. So when things are overseen by somebody who knows what they're doing, they move a lot smoother for me. So anything that can help a case move through the system, I'm a big fan of that.
Thank you. Okay, Judge Yu, I think that's it for our presenters.
Thank you so much, Leah, and thank you to all the presenters. And I'm going to open it up to questions. So the first hand I saw up was Carolyn, and then Steve Fleischman's hand.
Hey, thank you. Thank you, everybody. I mean, it's just an amazing group of really experienced people who know this in and out. And I'm not an employment specialist, but I know some of you are. So if you bear with me with some of my questions, I know a few good ones, but I'll try and ask just one or two and then let my colleagues get in, and maybe I'll have some follow-up. But one of the things I noted when all of you were speaking was the intense adversarial nature of these kinds of things. Not just, this is, I don't want to belittle anything, but it sounds to me like on either side of what's going on here, it's intense and it's detailed, and it's time consuming. I gather in terms of competency, that's one of the issues we're talking about. So I'd like to ask pretty much anybody who wants to speak up about it. You've all got different flavors of experience. And I don't think they teach employment law class, maybe they do now. What kind of training extensively do the people who got from you get in order to deal with the dozens of statutes and regulations and the layers from California Department regulations to federal court statutes? What do you give people realistically to make sure they're competent in this area on their own?
I would like to add that the legislature has been quite prolific recently, and there are laws that are constantly changing, statute of limitations and all sorts of other complex issues. There's also case law, but the training, I teach a class in employment law that goes with the clinic, and it's a standalone class. It's not before the clinic or anything. And also they do teach employment law, but it's not very practical.
I'll add just from my firm and my perspective and our employment team, I haven't counted in a while, but I'd say we have about 12 to 15 employment attorneys, and we do monthly training for our associates to make sure that they are up to speed on wage and hour laws. It is ever, I mean, the laws, there's a new law, at least one new law every year, if not more. And there's a case, not exaggerating, every week, probably more, that changes the law, puts another reflection on the law, another contour on the law. It is I guess I would call myself an employment law general practitioner. I don't know if that name exists, but that's what I call myself. I don't specialize in just wage and hour or hostile work environment. I do it all. And I would say the bulk of my training, knowledge, making sure I know everything that's going on time is on wage and hour, because it is so complicated and changing almost on a daily basis.
Thank you.
I hope that answers the question.
Yes, I'd like to hear from Director Aubrey about
sorry,
levels.
Carolyn, as the chair, let me chime in, okay? What I noticed was that Ms. Jones has her hand up, but Ms. Silvertaub's sound cut out. So I wanted to check and make sure she had answered the question fully.
Oh, I did want, I wondered why I was in the middle. I'm sorry.
I know you were in the middle of speaking.
Yeah, thank you so much. Yes, I did want to say that those organizations like CLEWA and SELA, they're constantly having conferences. They have all sorts of information. We're up on every case, and they blast it out to all of us on the listserv. So that's how people are educated, because people that are in those organizations are very motivated to learn the latest law as well. Yeah, thank you.
Ms. Jones?
Yes, thank you. So I agree with the speakers on the call that this can be a complex area of the law, but I don't think that should stop us in the sense of, the spirit of what Ms. Wilson laid out in the beginning was really helpful for me to think about in terms of the training, the education requirements, universal education requirements, in addition to contemplating folks actually having their JDs or their LLM. So we're talking about highly trained people potentially working in this space. The other thing that this question conjures for me that might help in terms of context is, as I mentioned earlier, I've done these cases on my own individually in my capacity as an attorney, but I've also worked with dozens and dozens of law students to do this work in a quarter, in a 10-week time frame, and do it well. And they're in training. So when I think about whether or not I think it's possible, feasible, on the table, something that can be done, and whether or not people can actually be trained to do it, my perspective is the answer is yes. Now there's a lot of detail and nuance that would have to be worked out, but hearing Mr. Aubrey speak as well, from my perspective, I think I was really transparent because I've represented workers. My interest would very much, as a practitioner in the state and being a public interest attorney for 20 years, would just be to see an expansion of the representation for workers who otherwise would not be able to get representation, either because they don't have a super strong case or because they just aren't able to find someone to assist them with breaking that case up. So all of that to say, yes, it's complex. Is it so complex that someone couldn't actually, with training, education, and some additional how do you say, guardrails, do it and do it well, I've seen it. So if I can train someone to do it within a 6 or 7 week period, both breaking up the case, assessing the case, presenting the case before the DLSE, it seems to me that someone who would receive $1,000 plus of experiential training could do something like this. And that makes me sort of excited and hopeful for the prospect of it. I guess my perspective is I would hate to see the technicalities stand in the way of workers getting representation. I understand there are different voices on this call, but my voice is lifted in the context of hoping to empower workers. So I do think that it can be done.
Thank you. I believe Carolyn wanted Mr. Aubrey to also respond if he would be willing to.
I'm willing. Yeah, I wasn't quite sure what your question was really asking, Carolyn. Were you talking about training these paraprofessionals? When I think about training the deputies, that seems to me kind of to be very analogous. You've got these people, you know, it used to be in the old days, back in the 70s and 80s, the people who became deputy labor commissioners came out of the union movement. So they had a background in employment law, but that sort of changed during the 80s and 90s. And you're getting people right out of college who wanted a government job and were attracted to the labor commissioner's office. I've actually guest lectured at Stanford in their employment law classes, doing like a 1 day, 1 hour presentation on wage and hour law. And, you know, the deputies that get trained to be deputy labor commissioners, they get training. When I was labor commissioner, we'd have 2 and 3 day retreats. We went to Asilomar 1 year and we sort of did the whole panoply of wage and hour law and the labor commissioner's jurisdiction, training the deputies. And I know they've done that over the years. There's also a large manual, which I'm sure all of the practitioners on the call here who do labor commissioner stuff, the DLSE policies and procedure manual that practitioners look at to figure out what the law is. You can't really know it all. A lot of it's very detailed and very nuanced in terms of the facts. So you've got to look it up. There are opinion letters that have been written over the last 40 years that detail specific issues, and those are all collected in the policy manual. So I agree with the speakers that say that it can be done. You know, it's complicated, but it can be learned and it can be applied. And in some ways, there's a kernel, a core of it that is really straightforward, that involves most of the cases, that isn't that hard to learn. I'd be curious if what the other speakers think of that point.
Thank you. Carolyn, do you feel like you got your question answered?
Yes, thank you. I have one, but I'll ask it later after everybody, if there's time, everybody goes around.
Okay, I'll come back to you, Carolyn. We'll go to Steve Fleischman now.
Hi, thank you. I have some questions for Judge Manoukian and Ms. Lutz. I'll try to get straight to the point. Judge Manoukian, one issue we are trying to address is whether there is a need for paraprofessionals to represent workers in Superior Court in wage and hour cases. It is my view that where there are statutory attorney's fees, plaintiffs in those type of cases don't have problems finding attorneys to bring them. And I think that's borne out by what Ms. Lutz is telling us. I know, for example, in the lemon law area, we see claims of relatively small value where plaintiffs have no problem getting attorneys. And they then, at the end of the case, where there might be a settlement for $15,000, move for $400,000 in fees. I don't know why that wouldn't apply equally to employment cases. And so I'm wondering what your thoughts are on that.
Well, interesting you should bring that up. I just submitted an article for publication in the Association of Business Trial Lawyers magazine that's going to come out soon on attorney's fees. And as you point out, most of those cases, the lemon law cases, settle for very little money. And then we see these horrendous fees being generated. And I probably get a couple of fee motions, 2-3 motions a month involving fees on lemon law cases, and then another motion or two on other attorneys' fees cases. And yes, where there are fees involved, there are attorneys who are going to be more likely to take those cases than not. Whether or not there ought to be consideration of changing the fee right to fees to make it a two-way street for the employer to collect as well is something that might be looked into. But there are a lot of cases where there is really not that much money at stake, even on a good day. And are we going to see attorneys willing to post a $500 filing fee on a case where the amount in dispute by the employee is $500? You know, that's going to be interesting. I really think that if there is going to be an issue with fee disputes, it's going to be handled like anything else, that you have a judge looking at the claim fees with a cynical eye, whether it's claimed by the employer or employee, and look to see why is there a billing for 4 hours to submit the judicial council approved form interrogatories for employment cases. You know,
I guess
that kind of thing.
But my question is, are you observing pro per plaintiffs in wage and hour cases where attorney's fees are available, or is that the rare case because usually they're able to find counsel?
That is a rare case, because if it's a good wage and hour case, they have a lawyer.
All right.
And I suspect that I usually ask, are you going to talk to a lawyer about this? So, well, I can't find one. I've talked to several lawyers. That kind of tells me something that I put out of my mind, because maybe they spoke to the wrong lawyer. Who knows?
We have several volunteer attorneys, and we've never had trouble finding a lawyer for these clients because of the attorney's fees. But often, you know, some of these cases where you think it's small, they misclassified, you know, there's all sorts of issues there. There's the penalties and that were mentioned. And also the rules for domestic workers, if it's a wage order 15 or a wage order 5, and then if they are live-ins or not live-ins, you know, there's lawyers that really understand the complexities of that and regularly take those cases and do a really good job.
Yeah, I do keep on my bench a stack of referral slips to the Alexander Law Clinic, and not only for employment cases, for just about anything, because I know you have a lot of eager, ready, willing, and able law students to look for something, and some of them are in my class that I teach now. So
to me, that's a sign the system's working, not that it's broken. I had a question for Ms. Lutz. When you're settling these small claims that you describe that you work on regularly, what I understand is that based on settlement letters, a very large percentage of the overall settlement, which may be $2,000, $3,000, $4,000, is attributable to attorney's fees, and that the worker's actually getting a small percentage. A, am I right? And B, just to be clear, I'm not attributing anything ill to the plaintiff's attorneys representing those workers. It's just my point that a worker with a relatively small monetary claim was able to find an attorney. Tell me I'm right, tell me I'm wrong.
A, you're right. And B, you know, San Diego's a pretty small place to practice law. We all know each other, especially in the employment law arena. And I get along with the plaintiff's bar here pretty well. And that is a conversation, as I said before, to repeat, you know, that they say every day to me, Jennifer, if your client doesn't pay X today, on this, we're going to go ahead and file a lawsuit. And as I said before, there's going to be a petitions fees for $200,000, $300,000, $400,000 at the end of this.
So hypothetically, if you
go ahead, please.
Hypothetically, if you settle a wage and hour case, and I'm just picking a number, $3,000, how much of that's actually going to go to the plaintiff versus the attorney? In your experience?
I don't always see what happens on the back end. You know, my estimate would be a third goes to the former employee, but I don't know that I'm the best person.
Well, when you see settlement letters, what is the average percentage of lost wages relative to the overall demand?
Oh, gosh. I don't know that I can give you an average. It just depends on, is this an overtime case? Is this a meal and rest period case?
Okay.
They aren't always taking the money from the plaintiff's wages because there's so many penalties. If it's a PAGA claim, there's other, you know, it doesn't usually come out of the wages if there's litigation, because if they don't pay minimum wage, there's liquidated damages equal to whatever the minimum wage is, waiting time penalties, there's the 1 hour, well, 2 hours total for rest period and meal period. So there's quite a lot of penalties on top of the wages.
And this is Carolyn. I got to jump in here because we don't have anyone from
Carolyn, it's not your turn yet. Okay, let's.
Well, I take umbrage. I'm not going to take offense at some of the comments here. That's how litigated this stuff is.
Say whatever you need to say when it's your turn, but let's finish with Steve. Go to Ira. I have a question, and then go to Carolyn. Go
Erica,
ahead.
Erica, I'm done for now. I may have questions later.
Okay. So Ira, you're next, then I'm after you, and then Carolyn. Ira, you're muted.
I was doubly muted. I wanted to point out something first, that many of the claims, like the penalty claims, are, I think all of them, or nearly all of them, except PAGA, don't have attorney's fees provisions. And they're often the largest part, as somebody just said, of a wage claim, wage and hour claim. Oh, some of you don't know, that's been my specialty too for about 20 years. I wanted to ask, I guess, Judge Manoukian, about if there are, well, let's see, Danielle Jones already talked about, well, many of the people who don't have the real strong claims don't get lawyers, don't get representation. And so I wanted to ask you if well, I'll just tell you what I think is true, and you can say if I'm wrong, that as far as Superior Court wage and hour cases, aside from the class actions and the PAGA cases, if a lot of employees have claims that are decent but not real strong and can't get lawyers and therefore don't file a case in the Superior Court, you wouldn't know about it, right?
I'm sorry, if they don't file cases, I didn't hear the
Yeah,
end.
they can't get a lawyer because their case isn't real strong. If you're a contingency lawyer, you need to have a pretty strong case, especially if it's not a class action, you know, if it's an individual case, not a big amount. All right, so if they don't find a lawyer and therefore don't file a case because they're afraid to go into a court on their own or don't know how, you wouldn't know about those cases.
Correct.
Right? So
Yeah,
you don't know if the system's working for those people, right?
That's absolutely correct.
Yeah.
I also don't know if the system is working like in that cement contractor case I said about earlier, where the employer said, you're all illegal, I don't have to pay you, and there's nothing you're going to do about it. And, you know, some people get frightened by risk of deportation, so they have a cultural fear of the police. My dad was a orthopedic surgeon trained in the old country. When he came here, he had a morbid fear of judges because every judge he knew in the old country was corrupt, bakshish, bribed, you know. So we can't account for the people who don't show up or why they don't. So yeah, and that's a concern too.
Thank you.
Ira, do you have any other questions?
No.
Okay, I know Leah also wanted to ask questions. Leah, would you like to go? Because Carolyn's already asked something and you can go before me.
Okay, sure. I just wanted to kind of focus for a moment on the Labor Commission process. And so if I understand it correctly, non-lawyers can already represent workers in wage and hour hearings, correct?
Right.
And what we've been contemplating in our group is licensing non-lawyers to provide legal advice to prepare for those hearings. So we can't address the fact that they're already authorized to represent parties in the hearings themselves. But what we're talking about is the ability for licensed individuals to provide legal advice outside of the hearing, essentially in preparation for. And I heard from Ms. Jones and from Mr. Aubrey that there could be some value to that. I think Ms. Jones talked about bricking up the case. Mr. Aubrey was talking about gathering documents, information that would be needed, and that in the absence of representation, the hearing officer is kind of taking control of the case and helping ensure that that happens, but that there would be some value and utility in having some other party do that. So I kind of just want to focus on that piece for a moment. Licensing non-lawyers to provide legal advice to help preparing for Labor Commission hearings. And just really understand what the position is to the extent that you all have one as our panelists on that particular set of activities for licensed non-lawyers to perform. So maybe that's really for Ms. Jones, Ms. Silvertop, and Mr. Aubrey, but others, any of you that want to weigh in, I just kind of want to hone in on that particular piece.
Yeah. Ms. Wilson, I can comment on that, and I do have an opinion on that. Maybe before I give you that thought, though, I do completely agree with Mr. Spiro's last point. I don't know if we actually have the data points about how successful plaintiffs are or claimants are in the Superior Court realm. I would think that only the strongest of strong cases end up in Superior Court. But bringing it back to your point, Ms. Wilson, about the DLSE, which is designed to be accessible and informal. So yes, there is a point of entry that is different for the DLSE than Superior Court. And I think a lot of workers fall into the DLSE category. A lot of workers are undocumented, so they have a lot of other concerns. So when I think about, you use the parlance that I used, which is bricking up, and that is how I think about these in many of the cases that I've worked over my career, which is how do you present this case in a persuasive way? How do you bring all the information together, brick it up for presentation? I think that while some workers out there are very sophisticated, and I do not want to underestimate their capabilities on any level, I do think help with document review. I think pulling together pay stubs and trying to do an assessment of what the claims look like, helping with calculations so that you know what you're asserting to the actual tribunal. This isn't guesswork. These are all things that a claimant would have to present in a clear, cogent way so that the hearing officer can actually make a finding in their favor. And so I think, we talked about what those calculations look like. It goes beyond just the fundamental wage and hour calculations of unpaid wages. We're talking about all manner of penalties that would attach that also require analysis of people's time cards, if they exist, and other documents that an employee might have that would help an advocate, a lawyer, non-lawyer advocate, whatever the case may be, brick that case up and present it in the best way possible. And then when you think about preserving that record for potentially a Superior Court appeal, it's even more important for the DLSC administrative realm to have that as a tight case that then can be dealt with if it is appealed by the employer, to give that worker the best possible position as you go to the next level. So I really think that in some ways, I don't want to oversimplify the process. I do agree with most speakers on the call that it's complex, but I don't see that complexity as a roadblock. I see it as something that should be taken into consideration when you're designing a program like this. And to my point earlier, training, ongoing education, do they have a JD? They're already trained to understand how the law is structured. So yes, I do see an opening and an entree for support for workers in this realm in that regard.
I wanted to weigh in on this. I think it's important to have a lawyer at the beginning to make a determination as to how to, the strengths and weaknesses of the case, what needs to be done. So I do think that's important. The other thing is that the statute of limitations is 3 years at the Labor Commission. It's 4 years in court. So you can get a whole extra year. And I'm worried that paraprofessionals who want to make money and keep these cases might think, I'm going to keep this case, even though I would refer it to an attorney. Whereas, we're not earning anything and we're passing them on. We do that assessment at the beginning on the front end of every case. And we also really work with the clients. And I haven't had the same experience with my law students, that they've been able to pick it up and do a really great job right away. They're always consulting with me, and even the new attorneys are always consulting with me.
Thanks. Mr. Aubrey, were you gonna?
Oh, yeah, I was going to say that I wanted to piggyback onto something Ms. Jones said about the calculations and working all that out. Sometimes you can't make those calculations unless you have some of the employer's records. So this notion of a representative helping with a subpoena to get some of those records before a hearing, it seems to me might have some value. And just a quite slight quibble with the Silver Taub about not all of the cases go with the 3 and 4 year statute. A contract claim at the Labor Commissioner is going to be 4 years.
That's true, is 4 years.
Right. So
But
certainly some of the statutory ones, and you get with the Business and Profession Code 17200 claim in court that you couldn't get at the Labor Commissioner. That's true.
Right, because you add the extra year. The other thing too is that at the Labor Commission, you don't need a subpoena now. You can just write away for the records. We have a form, a standard form we use, and you can write away and you have a right. And if they don't give it to you within 30 days for the personnel file, 21 days for the payroll record, you get $750 each, so $1,500. So there's not a subpoena there.
Yeah, those are provided by statute, though.
Yes, by statute, exactly.
Process, right?
I'm sorry, Mr. Aubrey. I feel like you were cut off a little. Would you like to say anything else?
No.
No. Okay. No, don't worry, Mr. Silvertop.
Oh, sorry.
No, don't worry. Just want to make sure he can give a full.
Sure.
Leah, did you want to hear from anybody else on your question?
Sure. Anybody else that wants to weigh in? I know we've got a couple of subcommittee members too that look like they're eager to speak. So I thought those 3 would probably have the most to say on that particular topic.
Thanks. And also if Justice Petru or other staff members wish to ask a question, please let me know. Before we go to Carolyn and Steve, I wanted to insert a question. So first of all, I appreciate Leah's question. It was sort of along the lines of my question, but I have a couple follow-ups. Earlier, Ms. Silvertaub and Judge Manoukian were talking about the fact that, Judge Manoukian has the referral forms on his bench, and Ms. Silvertaub can provide so many services in so many languages. But we're looking at a statewide program, and there are counties that we know are sort of legal services deserts. So I was wondering if Judge Manoukian's experience and Ruth Silvertaub's are more related to Santa Clara, and if they know or specifically Ms. Silvertaub, are there services available for people in other areas of the state? Because I feel like we're so blessed in Santa Clara County to have so many services.
There are, and that was my several page list in my PowerPoint. Those are all legal services area organizations, and they also provide services, and they're all either working under the supervision of an attorney or attorneys that actually work there. And so they do cover most of the country. I know CRLA is in many places where you wouldn't expect them to be. And all those pages are basically legal services organizations.
Before this meeting, I was late because we were talking about serving smaller counties, and people were talking about Tulare County, for example, or Trinity, where there may not be a lot of services. Do you know if there are legal services agencies, Ms. Silvertaub, in those small, what we sometimes call cow counties, to assist people?
There are ones that are in proximity. So usually the ones that are close enough, like there's a Grayton Day Worker Center that works with an attorney. I didn't put all the worker centers in there, and they work with attorneys. So there pretty much is.
Oh, your sound. Oh, sorry.
Oh, I'm sorry. I don't know what's happening.
Pretty much, there pretty much is.
Yeah, there pretty much is coverage in the sense that, well, now we'll take cases, from other places that because it's all virtual, but there are legal services or worker centers that people can call, and that will take their cases if there isn't anybody around. And I know legal aided work has continued to expand. And as I said, CRLA has as well.
And this is Justice Petra, just for 1 second, and I wanted to follow up because that's not what we're hearing from our judges who are in the more remote counties.
Really?
The judges that we've spoken to in those counties are seeing many people in these kinds of cases unable to get any kind of representation or help. And so I was a little surprised by what you said and wonder if, of course, I'm sure you're correct that these organizations exist, but do you know whether they actually have been representing people, showing up, pre-COVID in places like Tulare or Trinity or various places?
MODOC.
I don't know. I have heard about people who have got representation from there, but of course, you would know more what you're seeing there.
Okay, thank you. And Justice Petra, did you want to say anything else about that? I have one.
No, I don't want to hold things up.
And then Ms. Lutz, I think I saw you raise your hand. Did you want to say anything on this?
No, if I did, I haven't gotten zoomed down a year into this, so I apologize if I pressed the wrong button. No worries.
My last question is to any of the panelists who want to say, and perhaps to Mr. Aubrey, Ms. Silvertaub said now you don't need a subpoena and you get fined as an employer if you don't turn over records. But are those rules and access clear to lay people who represent themselves? Could they figure that out themselves, or would they benefit from a paraprofessional or somebody who would be able to tell them this information?
Well, my position would be they would benefit from having a paraprofessional tell them. There's a brochure. If you look on the Labor Commissioner's website, there's a pamphlet on wage claim processing, and it runs through the whole process of how the Labor Commissioner wage adjudication procedures work. And they talk about the subpoena there. They don't talk about the statutory authorities that Ms. Silvertaub was talking about. Most of the time, you get a demand for those kinds of records usually when an employee has left the company and they've got a lawyer and they're thinking about suing the company, and they send a demand letter and they want the personnel records, and if they're going to make a wage hour claim, they want the payroll records. Employees on their own don't necessarily do that unless they already have a lawyer, but the lawyer hasn't outed him or herself yet, and they're writing it. It's basically a canned letter from a lawyer. So,
and they also have videos that are excellent too, on running you all the way through the hearing and the conference and everything that you described.
Okay, thank you. So Does any staff member who hasn't asked a question want to say anything or ask a question before I go back to Carolyn? Okay, Carolyn, you're up.
Okay, so all right. I apologize for butting in there, but I'm really hopeful. There's sometimes I've heard in the last year and a half, 2 years of listening to these, you know, the kind of the ATILs and now this denigration of attorneys who are just in it for the profit motive. And I hope we don't devolve into a he said, she said about whether plaintiffs lawyers make too much, whether defense lawyers make too much, et cetera. So I'm just make that comment. I hope that's not the goal or intention or the motivation of anyone, you know, to get that titter. This is massively adversarial, more than probably anything in the country right now. But my question here is again, this is a sharp question. My understanding is that in some of these situations, workers are asked to sign settlement releases that A, may be confidential, and B, may release the employer from any other further action on any grounds. So I just like Mr. Aubrey and Ms. Lutz, who I think practice in this area, are they aware of legislative efforts to stop confidential settlements? Are they aware personally of the language that they have in their settlement agreements that make workers, in exchange for these back wages, release all like sexual harassment claims, any kind of other claim that they might release employer?
I'm sorry, did someone want to answer that?
Hey, you go ahead, Jennifer.
Yep, sorry, I was trying to find my mute button. Yes, I mean, there's definitely legislative efforts to limit the confidentiality of settlement agreements. So for example, my sense of time is not great anymore. Last year or the year before, you can't have confidential settlement agreements when it's a hostile work environment based on sex, for example. Those can't be confidential. So I would say every year there are efforts to make having confidential settlement agreements less and less. So hopefully that answers your question on that topic.
Now, let me add something to it. I was thinking about it before. I think it was Mr. Fleischman's question about these smaller wage hour settlements with an employer. And, you know, my experience is really that I don't get wage and hour demand letters solely on wage and hour. Usually you get a demand letter after an employee is terminated or leaves the company. And you get a demand letter, there may be some wage and hour aspects to it. But there's also a discrimination claim or something like that. And so when you're trying to resolve it and settle it, it's not just the claim isn't valued based on just the wage and hour stuff. There's also the potential discrimination claim. So you're taking all of that into account, and you're not really wondering whether or not the employee is going to have his or her wages not fully paid, because in fact, you're probably going to settle it for much more than the actual wages, because you're also taking into account the discrimination claim. So to come back to the other part of your question, Carolyn, yes, when employers settle those kinds of claims, they're looking for a complete release, because usually there's more than just a wage and hour claim involved. And sure, if you're going to pay any kind of money, you want a complete release. That's what you do for your client.
But where employers are unrepresented, the Labor Commission has its own form, and the Labor Commission's form is really good for plaintiff attorneys, because if it's not paid, it becomes a judgment for the full amount, even though you agreed to take less. So we see that in a lot of cases, but you're right, with attorneys, they do want the full release. And
the Labor Commissioner release isn't a complete release. It only releases the wage claim.
Yes, exactly. And also the full amount too, but then collecting is an issue.
Would any of our other panelists wish to answer Carolyn Shining's and Carolyn's question? Carolyn, did you feel like you got your question answered?
Yes, thank you. It's a tough question, I know.
Okay, Steve, and then Ira was supposed to be next, but I think his hand might have gone down. Steve?
Ms. Lutz, in your experience as representing employers, do you find that only plaintiffs with slam dunk liability cases are able to find lawyers, or do you find that workers with debatable cases, even some cases where you may get summary judgment on behalf of the employer. Are they able to find counsel also?
Yeah, I mean, that is my experience with this spate of demand letters. There's good claims and there's bad claims. I think there's such incentive. And my point about the conversations I have with plaintiffs' counsel about their potential attorney's fees, motions at the back end of a case, I don't have a problem with that. I don't have that's a fact. And the fact is, for most labor code claims and most FEHA claims, there's mandatory attorney's fees for the plaintiff's attorney. And that's something that my clients absolutely have to take into the calculus, because even if it's a questionable claim or a bad claim, they're going to spend however long it is, year and a half, 2 years litigating a case, paying my bills, and then potentially paying the plaintiff's attorney on the back end of that as well. And that is an economic reality conversation I have with my clients every day, because that's something that plaintiffs' counsel say to me every day, because that's the law. And I do think that makes for an incentive for lesser claims potentially to be brought, and then companies have to make economic decisions about what to do with that. Does that answer the question, I hope?
Yes, thank you.
You're welcome.
Erica, I have no more questions.
I'm sorry, I just wanted to add one more thing too to Mr.
Sure.
Aubrey. I was going to say, so my experience used to be that I would get a demand letter and I was wrongfully terminated and I was discriminated against. And by the way, overtime and meal breaks and rest breaks and my pay stubs are wrong. That is my experience of late. I would say the past 3 to 5 years has been, we are getting a lot more letters that are wage and hour focused. And I do talk to my friends who are plaintiffs' attorneys, and they'll say, someone will come into their office and upset they were laid off. And, they'll go through the layoff and that seems legit, but let's talk about how were your overtimes? What were the meal policies? What were the rest break policies? So I'm definitely seeing many more focused wage and hour type demand letters and cases than I used to.
Erica, I did have one more question for Ms. Lutz, if you'll wait.
Okay, go ahead, Steve, and then it's Ira and then Greg.
Ms. Lutz, I'm seeing more and more advertisements where it seems like almost a virtual law firm will represent workers, and there may or may not be the traditional go into the office, meet with an attorney type of situation. It's all done sort of online, and this was even pre-COVID. I'm wondering if you're seeing that in the employment realm as well.
Yes.
Okay, thank you.
All right, thank you.
Thanks, Steve. We have 10 minutes left, so Ira and then Greg. Go ahead, Ira.
One point that Carolyn Shining brought up about the release and employers wanting a full release of all claims. Yes, they often do. Now, some of us plaintiffs lawyers just won't give it. In my class actions, I would not do it, at least after a few years when I learned not to do it. But in the individual cases for wage and hour, that is one place where a paraprofessional could really help, because it's not that hard to learn that you shouldn't give general releases if you can avoid it, and to figure out, to read the thing and see if it's a general release or if it's limited to the claims that you're releasing.
Okay, thank you, Ira. Greg?
I guess this question is for Ms. Lutz. I guess anyone else could jump in on this. So I'm lead attorney for the California Supreme Court and a liaison to this group. In my former life, I did exactly what you do, Ms. Lutz. So I have a question. I guess it's a follow-up to what Steve Fleshman asked. In your experience, how many times have you received a wage and hour case that was filed as a limited jurisdiction case in Superior Court?
It's a great question. And your job now sounds much more interesting than my current job, your former job. So I'm kind of jealous. How many? I couldn't give you a solid number, but it happens on a, I don't want to say regular basis, but it's not uncommon.
Interesting. That was never my experience, actually, when I was practicing. Usually the prayer for relief was well in excess of $25,000, even on a wage and hour case. And I usually saw most of those lower value wage and hour claims filed with the labor commissioner. But I wonder also, have you ever had a wage and hour case filed as an unlimited jurisdiction case and successfully had it reclassified as a limited jurisdiction case?
No.
I see Judge Manoukian is nodding, or so he may have a response for you, Greg, to your question.
Okay.
Judge Manoukian?
Yeah, first of all, I think I teach my students that the advantage to filing a limited jurisdiction case is that it cuts down on the discovery obligation. So if you've got a $10,000, $20,000 case, file it as a limited jurisdiction matter. Don't think you're going to knock that one out of the park for $1 million unless you really think you can, because it'll cut down on your discovery costs. And I'm sure those that do seek advice from a lawyer probably heard that from the lawyer as well. As far as reclassification, that's a subject I teach too. I cannot remember the last time I saw a motion to reclassify a case either up or down. It just doesn't seem to happen. To my surprise, actually.
Judge Manoukian, I know because I actually spoke to you about this. In terms of wage and hour enforcement of judgment claims, where do you think they should be, in limited jurisdiction and general jurisdiction? I understand you actually see about 2 of these cases a month.
Yeah.
And you see what the dollar amounts are that people are seeking.
They're usually filed as limited jurisdiction cases, but the only time it makes a difference is discovery purposes, really, from my end. You know, that the trial is the same, except, you know, that there might be a declaration or one person showing up for each side, something like that.
For our purposes, there's something else at play, but what's the dollar amount? Do you believe?
The case that I've seen, it's usually $10,000 to $20,000 in there or less even. Like I say, if it's a bunch of these cases, little cases like that, there's probably a lawyer somewhere vacuuming them up into a class action, or it's a bigger case where there's tort claims involved and so on. Most of the cases I see on Labor Commission appeals, wage and hour claims, are small amounts of money, not more than $25,000.
Okay, thank you. Greg, I hijacked your question, so I'm coming back to you to see if you want to follow up or have anything else you wanted to ask about.
No, thank you, Judge.
Okay, thank you. So we really only have about 6 minutes left. I see Steve's hand is up. Steve, why don't we have you ask a question? Hopefully it'll be rather quick and we can wrap it up.
Very quick. I was just going to respond to Greg. Greg, the incentive to file in limited jurisdiction relates to a Supreme Court case called Chavez versus City of Los Angeles and Code of Civil Procedure Section 1033, Subdivision A. If you file in unlimited jurisdiction and you get a limited jurisdiction judgment, you may not recover costs or attorney's fees in the trial court's discretion. And anecdotally, I would say I'm hearing more and more from defense attorneys of wage and hour cases being filed in limited jurisdiction because they are small value and to avoid the 1033A problem.
Okay. Let me just check and see if there's anybody else who has a question. Looks like no, because that's Steve's old hand up. So Leah, I'm going to turn it back to you.
Okay. Well, I feel like, you know, we could, if we had another 2 hours right now, we'd probably be able to knock this out, but we don't. So I think, Judge, you and I will have to connect and kind of figure out the next steps. I do think it's important because we spent some time talking about the availability of legal services, to just clarify that the population that would be served by a paraprofessional is not the population that's eligible for free legal services. So I want to make sure that we're all clear on who we understand this program to be targeting. Until there was universal right to counsel in wage and hour cases, we are talking about a population that does not necessarily qualify for free legal services. And the other piece that I think we really do need to understand, I'm having a cognitive disconnect with, there's so many lawyers that are going to take these cases. Essentially, there's no need. With what the Justice Gap study told us, which is why wage and hour was on our list of issues in the first place. And with, for example, this NELP report, National Employment Law Project, somebody referenced that only 17% of these DLSC judgments have been paid out, over a 5-year period that they looked at. So something is not happening. I'm not clear on what it is still, but I guess that those are my comments that I feel like maybe we haven't quite gotten, drilled down to exactly where we need to be. And other than that, I just really want to thank these panelists because I scrambled to pull you all together. Really appreciate it. And you can see from all these questions that, we needed to have you here, and probably need to call on you again. So thank you.
So thank you, Judge Manoukian and Ruth and Mr. Aubrey, and also Ms. Lutz, and definitely Ms. Jones. I think I know Margaret Stevenson, who maybe was working with your entity before. She's also come and talked to us. So thank you all so much. On behalf of our subcommittee, we're very grateful for your time and your expertise. And so for us, we have 2 minutes left. Our next meeting is March 22nd. I have a calendar, so I'll join you late, and I think Justice Petrie will be starting off that meeting. And I'll talk to you soon, Leah. And Justice Petrie, did you want to add anything?
Nope, I think we should let everyone go on time. And I also sharing the thanks for the speakers willing to give us so much of their time this afternoon.
Yes, thank you so much. I hope you all have a good rest of the week. Take care. Thank you.
Thank you.
Bye-bye.